Hello and welcome to See You in Court, a podcast that informs you about the Georgia civil justice system, what it means to you, and how it protects individual rights. During each episode, we dive deep into stories, cases, and insights that matter to Georgians. You can learn more on our website at www.seeyouincourtpodcast.org. Join the conversation on our YouTube channel at See You in Court Podcast, and stay connected with us on our Facebook page at facebook.com/seeyouincourtpodcast. This podcast is sponsored by the Georgia Civil Justice Foundation. Your hosts are Robin Frazer Clark and Lester Tate, who are both past presidents of the State Bar of Georgia and who both serve on the board of directors of the Georgia Civil Justice Foundation. And now this episode of See You in Court.
Good morning, friends and lovers of the law, and welcome to See You in Court. I am Robin Frazer Clark, and with us here today is our co-host, the fabulous Lester Tate. Hey, Lester.
How you doing?
I'm good. How are you?
Good. It's a summer session here. We hadn't had as many lately, and
that's true.
And we've got a great guest today.
Oh, I know.
Put Judge Ken Hodges on the hot seat.
He's awesome. But speaking of summer, congratulations to you. Your daughter Grace got married, so that's great news.
Yeah, we went to Anguilla and had a great time. At the end, she said this was all perfect, and I thought that's all you can ask for, for your daughter's wedding. That
is awesome.
Very excited for her and CJ, her new husband, and of course they're living down in Charleston, and just glad to have him in the family as well.
Awesome, that's great. Well, today, as you said, we've got a wonderful guest who we both have known for a very long time, but I'm excited to introduce our listeners to him, Judge Ken Hodges of the Georgia Court of Appeals. And we're going to explore a little bit about what the Court of Appeals is and his judicial philosophy and his career, which is just, when I look back on it, just amazing. But let me tell our listeners a little bit about Judge Hodges. The Honorable Ken Hodges III was elected to the Court of Appeals by the citizens of Georgia in 2018, winning every county in the state with wide bipartisan support in a contested election for a rare open seat on the court. Judge Hodges took office on January 1, 2019, and was elected again statewide in 2024. With deep experience in diverse practice areas, Judge Hodges has served as a prosecutor, defended criminal cases, and been on both sides of a dispute in civil matters. He has been a court-appointed receiver and a mediator. Judge Hodges is applying this experience on the bench to uphold the rule of law and ensure justice for all. Judge Hodges was born and raised in Albany, Georgia. He graduated from Episcopal High School in Alexandria, Virginia, and earned his BA from Emory University in political science and sociology with a minor in English in 1988. While at the University of Georgia Law School, he participated in a clinical program with a public defender and was sworn in under the third-year Student Practice Act to try cases. He earned his JD from UGA Law School in 1991 and set out to become a litigator. After working with a litigation firm in Atlanta, he returned to Albany as an assistant district attorney. Judge Hodges was elected district attorney of the Dorsey Judicial Circuit in 1996 at the age of 30. Within the first 2 years, he cleared out a backlog of 8 death penalty cases and took them to trial. He formed trial teams which effectively ended unnecessary delays in moving cases forward and focused on laws and programs to better protect children in the county. This included a child prosecution unit, a child advocacy center, a truancy program to target unauthorized school absences, and he also established a sexual assault unit. In his second term, he was named District Attorney of the Year for the state of Georgia. During his 12 years as district attorney, Ken was committed to managing an efficient office which operated under budget every year. He was elected president of the DA's Association and also served as chairman of the Prosecuting Attorneys Council. He was appointed by Governor Roy Barnes as chairman of the Legal Loan Forgiveness Task Force and as a member of the Certainty in Sentencing Commission. In 2008, he returned to private practice, working in transactional law and then litigation. In 2015, Ken started his own law firm, Ken Hodges Law, based in Albany and Atlanta with a focus on commercial litigation. Judge Hodges was elected president of the State Bar of Georgia in 2018 to 2019, the first judge to lead the organization in its history. He currently serves on the State Bar's Office of General Counsel Oversight Committee, is chairman of the Advisory Board for Truist Albany, and is chairman of the Albany-Doherty Airport Commission. Ken also serves on the Board of Advisors of University of Georgia State Botanical Garden and the Board of Directors of the Southwest Georgia Legal Self-Help Center, a nonprofit that works to improve access to justice for low-income people in the region. Judge Hodges has widely been recognized for his legal and civic accomplishments during his more than 27 years as a practicing attorney, including as the recipient of the State Bar's Commitment to Equality Award, the Justice Benham Award for Community Service, and the Eagle Award from the Criminal Justice Coordinating Council for his work on behalf of crime victims. He is also an avid pilot, and I think we'll talk about that since we have two pilots in our meeting today. And he enjoys being up in the air like his father and grandfather, a naval aviator, before him. Judge Hodges, welcome to the show.
Well, thank you. And I'm not the only former state bar president on the podcast either.
This is true. We're getting the band back together with the three of us.
Right.
Which is
and probably the most familiar person of the road between Albany and Atlanta, huh?
I make that trip way too often. I can do it almost with my eyes closed.
Especially if you're driving a Tesla, which I doubt you are. But
no, I'm not. But I've thought about it, actually, with all the driving I do. I put probably 35,000 miles on my vehicles each year. So I've actually thought about a Tesla. That might be my next car.
Ken, Judge Hodges, I love the your bio. I mean, just so impressive. And it every time I know we've been friends for a long time, but every time I look back at that, I think, wow, that's so impressive. I want to talk to you a little bit about first your decision to become a prosecutor, criminal law prosecutor. It may have happened when you were in law school doing that third year student work in trials, but what led you to decide that?
Well, I think largely that. Also, my father was an attorney. He went back to law school late in life. He was 35 when he went back, and my sister and I were in middle school. And so I actually have been to law school twice. I went with him and then came back and went through it myself. So I watched him. He was the public defender in the municipal court in Doherty County. And during the summers, I would go watch him and the prosecutor try cases. And then in law school, I did, as you said, the Third Year Practice Act, and actually first chaired a criminal felony trial my third year. And I kind of had the bug. And when I went to Atlanta, I went to a litigation firm. And litigation is a fancy word in Atlanta back then for pushing papers around and filing motions and taking depositions, but never going to trial. And I got a little frustrated and I wanted to get in the courtroom. And so they didn't have public defenders' offices like they do today. So that wasn't an option. The DA's office in Albany had several openings, and I went home and interviewed and was hired immediately, and candidly thought I would do that to get experience in the courtroom for a few years before going ultimately to practice law with my father. I didn't do it as long as I thought I would because my father unfortunately became ill and had to withdraw from the practice of law. And I left the DA's office, a job that I loved, to go take over his firm and his practice. But ultimately missed it. And that's when I decided in 1996 that I needed to run for the job and was elected and did 15 total years, 12 more as DA as a prosecutor.
Well, that's wonderful. Describing going to watch your dad in court sounds a little bit like the real version of To Kill a Mockingbird.
Well, it was, and he had seersucker suits as well. It really was. It was small town Albany, and it was also small court, being municipal court, and so there were really matters of not great importance, but great importance to the people that were there. And I would sit in the jury box because there wasn't a jury in municipal court, and I would watch my dad. And it was then Lauren Gray, who later became my dad's law partner, and then later became the Superior Court judge and even the chief judge. He was the judge that swore me in as district attorney, actually, ironically. But I would watch the two of them go at it in the courtroom, and then the two of them, along with the judge, would walk across the street to the coffee shop afterwards and sit around and drink coffee together, all three of them and me. And they would rotate paying for the coffee, but I would order a milkshake, which made them mad because that cost more than the coffee. And I would sit there and listen to them tell war stories. And it was just fascinating. And what a great way to spend summers as a young middle school boy.
I'm gonna jump in and give my favorite Lauren Gray story, because when I was president of the bar, flew down there to go talk to the Albany bar, and he was retired then. He picked me up at the airport, and he said that he had gone bird hunting with the late great George T. Smith, and he said that George T. he called him Justice Smith, and he said, don't call me that. I'm just George T. And he said, no, you're a very important judicial official. And he was on the 7-member, Supreme Court at that time. And George T. said, no, Lawrence look, you're an important judicial official. You're a Superior Court judge. You can send a man to the electric chair, take his house and his kids away from him. You've got all sorts of power. He said, I gotta get 3 other jackasses to go along with me before I can do anything. So now, unlike your dad that could do everything, you've got to get at least one other person to go along with you there on the Court of Appeals, and maybe more, I guess, if it's an en banc.
Well, that is correct. We certainly don't have the power of the trial judges. They can do a lot more than we can do, even though I guess we can reverse them. But I feel exactly like George T. in that regard.
Yeah, that was a knowing look on your face. Is like, I know of which he speaks. Tell me, Judge Hodges, is there one, going back to your career as a prosecutor, is there one memorable case or one that sticks out more than the others to you? Is like, wow, that was the case of my career as a prosecutor?
Well, as you mentioned, the first 2 years in office, I had a backlog of 8 death penalty cases, which is really, candidly, one of those in particular was the straw that broke the camel's back that got me to run because of the mishandling of those cases and that one case in particular. And so trying each of those was very meaningful, and, dealing with the victims' families and getting them to justice. But the one that I guess stands out the most would be the case that emanated out of Atlanta and got moved down to Albany, and that's the state of Georgia versus Sidney Dorsey.
Big case. And I happen to have J. Tom Morgan's, who's a fellow prosecutor of yours in that case. I have his book here, and we're fortunate to be able to have J. Tom visit with us our next recording. But you appear in that book quite a bit as the prosecutor, the district attorney in Albany. The case got moved down there, kind of surprisingly. It was supposed to be going to a different county, but it ended up in Doherty County. And that was, in Atlanta, big news. I don't know if it's very big news in Doherty County, but that trial was on the news every single night. We watched you and J. Tom in action. Tell us a little bit about your involvement in that unique trial.
Well, J. Tom,
a bit about the facts too, because
tell us about the facts, because it's almost unbelievable.
Okay. So J. Tom was actually born and raised in Albany, Georgia. We're 10 years apart in age, so I didn't know him growing up, and we went to different schools. So the first time I met J. Tom was when I was elected DA, and he was already the DA in the Stone Mountain Judicial Circuit. And so we knew each other for a few years before that trial happened. And I'll never forget, I was driving up Dawson Road, which is one of the bigger roads in Albany, in my car, and the phone rang, and it was J. Tom. And he said, "Hodges, you're never going to guess where the case got moved." And you're right, Robin. It was set to either go to Columbus, Macon, or Augusta. Those were the three. In fact, J. Tom thought it was Augusta, and they had done some mock trial work in Augusta. And so I said, I don't know which one I guessed. I probably said Columbus, no. Macon, no. Augusta, no. And I'm like, "Well, what is it?" And he said, "It's Albany." And I said, "Okay." He said, "Well, I need your help." And my response to him was, "Whatever you need, J. Tom, what do you need?" And the help that he requested for me that day was he needed a place to stay because the trial judge had sequestered the jury, or was going to sequester the jury, and had quarantined off the largest hotel in Albany at the time, the only one that was really of use to, outsiders. And so I went to work and quickly found a hunting lodge because the trial was going to be during the summer, not during the hunting season. And I called friends of mine that owned and managed it, and they said, sure, they would let them rent the rooms in the hunting lodge. And so that was what I thought J. Tom needed my help with, and we'd be done. But then I got a call back, and he asked if I would help pick the jury, which I told him I would. And then the third call was, would I actually do the voir dire in the courtroom, which I told him I would.
Yeah.
The fifth call was, would I take a few witnesses, which ended up being about a dozen. And then the final sixth or so, seventh call was, hey, we think it'd be a good thing if you did opening statements. So the truth is I sat with him and his team, his very capable and awesome team, in the courtroom for the entire 3 weeks we were there, was co-counsel, I did the voir dire. I did the opening statement, and I did 12 witnesses or so, and participated in the strategy sessions with them at night. And it was just I hate the reason that we were there for Derwin Brown and his family. It was a tragedy, but it was professionally a great experience, and I'm glad to have been part of getting justice for the Brown family. And so to give you the facts in a short nutshell, for those that don't recall, this was back in the early 2000s. It might have even been 2000, September 15th. Let me back it up. September 15th was the assassination. But prior to that, Derwin Brown was a captain in the DeKalb County Police Department, and he ran against a popular sheriff, being Sidney Dorsey, who I believe may have been the first African-American sheriff elected in DeKalb County. He was a former Atlanta City homicide detective, and he was very charismatic, very popular, but he had a little bit of a rogue personality, and there was some undertones that he may have had some corruption. Well, that kind of bubbled up a little bit during the election. It turned out that there had to be a runoff because there were others in the election. And Dorsey was the number one vote getter in the first go-round. But then Dale Cardwell, an investigative reporter in Atlanta, helped uncover a lot of the corruption between the general or the first primary election and the runoff. And Derwin Brown ended up winning. And so in Georgia, the elections are in the early part of the summer. I can't remember when it was then, probably like July. I think they're in May now. But in any event, Sheriff Dorsey had many months before Derwin was to be sworn in to continue to be the sheriff. And so he went to his number one henchman, a guy by the name of Patrick Cuffey, and got Cuffey to come up with a plan to assassinate Derwin Brown. And he thought that if Derwin Brown were killed before he could take office, then there would be a special election to fill it, thought that he could go back in and run for the job and become elected sheriff again. And so Patrick Cuffey went out and recruited David Ramsey, blanking. I mean, this is y'all are asking me to go back 25 years. I can't believe I can remember all that I'm remembering. Paul Skyers and Melvin Walker. So that's those were the three others involved. So the four of them formed an assassination team. And I could talk for a whole hour about it. So I won't do that, but I'll say that they planned the assassination and they executed it on the 15th of December of the month prior to Derwin taking office in January. They did it at his house on his wife's birthday, killed him with a Tech 9. Either Walker or Ramsey was the trigger man. I can't remember which, and went in and shot and killed Derwin Brown, hit him with 17 or more shots. They were actually tried in DeKalb County and acquitted, believe it or not. I don't know why. I wasn't a part of that prosecution. Thankfully, the federal government picked it up and prosecuted them federally later, and they were subsequently convicted. And they both, I believe, are still in prison. Dorsey got moved to Albany, and we prosecuted that case both as a murder and as a RICO for all the corruption. And the corruption was widespread. I mean, it was as minimal as him having all of his staff perform personal functions for him, taking care of his kids, running his kids to and from school, taking them to restaurants, fixing cars, driving them on vacations. And if I got into the details, it's really kind of appalling, but that was it generally. But the biggest one was he had a security investigation company that he provided, on duty DeKalb County officers to entities, banks and other entities in Fulton County, and would be paid for their time. So in other words, they were on duty for DeKalb County. He would send them over there to do security for these banks, and he would be paid for them doing full-time security, and he didn't have any capital outlay. That was the biggest one, but all the others were pretty appalling too. And so he was convicted.
So he had a lot of incentive to remain sheriff, it sounds
right.
like.
And he had an arrangement with a bonding company that he was getting kickbacks from the bonding company. He was extorting both sex and money from the owner of the bonding company. And then it just really goes on and on and on. And if you want to talk, you will talk to Jake Tom.
We're going to talk to Jake Tom,
and you'll hear all of the details, the gory details, but they are gory and appalling and corrupt, and it was just horrible. So anyway, he went to trial. We convicted him. And of course, he denied it all the way through. He didn't take the stand. And then about 5 years into his prison sentence, he confessed and told that it did admit that he planned it. And then a couple of years ago, he died in prison.
Yeah.
So what would you say was sort of the weakest part of your case? Because you're making a connection. He wasn't the trigger man. What did you really have to prove? What was the linchpin in hooking him up with that?
Well, I mean, you had to believe two other people that were two of the four that were involved in the case. Now, we had corroborating evidence. In other words, Paul Skyers, who was the driver, who did not have a gun and did not pull the trigger, was given part of the gun that was actually used to hide, and he threw it down a sewer pipe. And when they went to the sewer pipe that he said it was in there. And there were other things like that Skyers and Cuffey testified to that we were able to corroborate with independent evidence. But we still had to have the jury believe Skyers and Cuffey. And Cuffey was not a very likable person. The only reason Cuffey turned on Dorsey is because he was involved in another shooting, and he wanted immunity from all of his crimes. And he got complete immunity for everything, which is distasteful, and nobody wants that to happen. But he was not the man that shot and killed Sheriff Dorsey. He was not the man that came up with the idea. And so J. Tom made a deal with the devil. I mean, J. Tom will tell you that was a hard deal to make, but it was easier to make it. He certainly wasn't going to make that deal with Melvin Walker or David Ramsey. I mean, he couldn't make it with them because they were the trigger men. And he couldn't make a deal with Dorsey because he was the mastermind.
Was that a death penalty case or?
It could have been death penalty qualified. I have to think about it and see if there were good, because in Georgia you have to have statutory aggravating circumstances to seek the death penalty. And I guess it could have been construed as a murder for hire. Yeah, it could have, because he wasn't giving them money to do it, but he was offering them future employment. So yes, it could have qualified as a death penalty case. But, from my experience in death penalty cases, and I've had more than a dozen of them, it has to be a slam dunk on guilt innocence. An absolute slam dunk before you want to seek, because there's a lot of resources, time intensive and whatnot in seeking the death penalty. But we got the death penalty because he died in prison.
That's true. And all the appeals that go with the death penalty should be
a lot more appeals, a lot more protections. I'm sure, I was about to say, I'm not sure. I can't remember Dorsey appeal, but he did appeal. I do remember that now.
When I read J. Tom's book, A Rainy Night in Georgia, that we're going to talk to him about, my conclusion was that every time he needed something, he asked Ken Hodges, and you were there. It just got more and more and more. It started with finding us a place to stay to doing half the trial, and that was my take on your involvement in the Sidney Dorsey case, is that you just kept doing more and more and more of the trial.
Maybe we should ask you, we've got J. Tom coming on. What question would you like us to ask J. Tom? Maybe that's.
I'll send you a long outline.
Well, I know you and J. Tom are close personal friends now. Were y'all that close before the Sidney Dorsey trial, or did you become friends?
No,
yeah,
no, but we are very close now. We're like brothers. He was in my wedding, and I'll see him this weekend.
I was going to say, I know you visit him in North Carolina, where he's a professor now. It's just that was an amazing trial to me, and as I said, it was big news in Atlanta. And the stuff of a novel. And J. Tom's written a nonfiction, but I swear I think it could be a great fictional novel also.
Well, unfortunately, it is nonfiction.
Right.
We could fictionalize a little bit more, and I'm surprised it's never been turned into a movie. It may be.
Me too. So now you're on the Georgia Court of Appeals, our second highest court in the state. You have tried as a lawyer hundreds of cases. Now you're reviewing them. And as a trial lawyer, Lester and I both love the fact that we actually have judges who have tried cases before sitting on our appellate court. That means a lot to us. I'm interested in your take on it, though, compared to trying a case like the Sidney Dorsey trial or those death penalty cases. Is it boring to you? Is it a little too mundane compared to what you're used to in the courtroom?
Well, it's absolutely a much different role, and it is more. It's even more boring on this court than being a trial judge. Of course, I'd never served as a trial judge, and so last year, or maybe it was 2 years ago, a friend of mine who's a Superior Court judge in Fulton County inherited a pretty large case against a incoming president. And so I told him, in order to help him with his backlog, I'd go over there and try some cases. And so I sat twice. The first time, I think everything pled out, and they were murder cases. So we didn't think they were going to plead out. But so I ended up presiding over a bunch of pleas. And then the second time, there was an aggravated assault that went to trial, and I actually presided as a trial judge. And it was fun. It was interactive. It was engaging. I had to do things, but at the Court of Appeals, it's mostly reading records. It's mostly reading transcripts and seeing what happened below, and then deciding a lot of times on procedural issues, not necessarily the merits. I mean, I may agree or disagree with the way something happened below. I may or may not have made that decision that the trial judge made in the split second that they had to confront the issue. But I need to decide based on the law that's in place whether procedurally it took place. And the way I describe to non-lawyers what I do is I say that the lawyers are the football players on the field playing the game. The trial judges are the referees wearing the black and white stripes and throwing the yellow flag. and I'm the instant replay guy. It's a very important job, but not as interesting as the other two.
You know, I remember when you did that trial, sat in as a designated trial judge, and it was on YouTube or it was live on the internet. I was able to watch most of that trial. I really enjoyed watching that. I thought that's pretty cool. You get to sit by designation as a trial judge.
Yeah, well, I didn't even realize it was online. So
it was. I remember watching it. Yeah.
How'd I do?
Trying something on YouTube is always interesting because then you go read the comments from everybody about how you did, whether you're a lawyer, or a judge, or whatever. I don't always want to read them, But
so speaking of online, before I forget, let me segue and say that we are online at the Court of Appeals. We live stream, so if anyone wants to watch oral arguments, they can go to our website and see our calendar and see anyone they want to see. Whether it's, their particular case or they just want to watch a case to see what it's like. And they're also archived, so they don't have to watch it live. My next oral argument, I think, is September. And I've got 2 cases on that calendar. But if you wanted to watch something after y'all see this podcast, I'm talking to the listeners. And if they want to see what goes on, just go to our website, click on any case that you want to see, and you can watch it. Archived on there. And the other thing, of course, during COVID, we were nothing but Zoom. Right. So I would be standing here actually exactly where I'm standing right now in my office. I wouldn't even go in the courtroom, which is right around the corner, because we were all staying away from each other. And I would participate the same way we were doing this podcast. And after that was over, I said to the group that we needed to keep that as an option because there may be a lawyer in Valdosta or Savannah, probably, more likely representing an indigent client or a criminal defendant that doesn't have the resources to drive up here and participate in an oral argument fully. And we need to have the option that they can do it virtually. And so in our court, I don't think the Supreme Court does it, but in our court, if they properly move forward, that and the reason is present, we will grant a virtual appearance, and they can appear virtually. And I did have one where that happened, where the lawyer was from Chicago, and they just appeared virtually.
And it has had no negative effect whatsoever.
Yeah.
Yeah.
Well, I mean, I think it's better in person, of course, because you can read language and body language, and you can interact better, and you can anticipate questions and when people are through talking and the right time to interject a little better than Zoom. So I think it's a little better. But, if you're talking an indigent client in Valdosta, there's really no other way to do it.
Yeah.
So, yeah, and I'm thinking about this. Because I'm sending you all a brief today, but I was sitting here and it was a case I tried, and it was like a week-long trial. And I'm sitting here thinking, I wonder how much on the Court of Appeals they actually look at the transcript as opposed to just the briefs, because the briefs have a statement of fact in them, and talk about that, and you identify in the brief your enumerations of error, what you say the judge did wrong, which may focus it a little more. But how important are the actual transcripts? I don't think I'd ever thought about that till this morning. When I'm sitting there and going back in my own mind over what happened, in the trial.
Well, we have one person on my staff who is designated to do all record checks. But the 3 staff attorneys also do record checks as we go through this. So it would probably shock you, as it did me, to know that sometimes people cite to the record to places where what they're citing does not exist or is misrepresented. So, yes, transcripts are very important. We have to make sure we are a court of review, which means if it's not in the record, it didn't exist. If you decide you're not going to have a transcript of a hearing because you don't want to pay for it, and that hearing is an evidentiary hearing that is dispositive of your issue, and it comes up to us, we're going to defer to the trial judge if there's no record. Because if there's no record, then it didn't happen. So it's vitally important, and we also double check to make sure that the representation made by counsel is correct.
That's interesting, because that's kind of one of the reasons I was thinking about the transcript. Is things that that the other side had said about it in their brief.
Well,
Very
if it's inaccurate, point it out and point us to the record.
I mean, very interesting, which also makes me, you mentioned that you'd be surprised that attorneys quote things that aren't actually in the record, but now we're seeing a lot of attorneys quote things from AI, totally made up cases. I don't know if your court has seen that. I know it has happened in the Supreme Court of Georgia a couple of times already. Has your court witnessed that?
Yeah, and I'm going to pull up something from my phone right now and give you a site to it that you should go look at.
Okay.
I authored an opinion that was about that. Let me make sure I've got it right. It's I think it was the Tolbert case. I think it was in Tolbert A25A 1439, where I wrote an opinion, but that may not, let me think if that's the one that, where I took to task a lawyer. I think that was the right one, where I took to task a lawyer for filing briefs that were very suspicious and seemed to be AI, and I actually admonished him to go back and do 3 hours of CLE, and required it as a result of doing that. So yes, we see it. We're dealing with it. It's not good, but we're prepared. And we only had sanctions available up to $2,500, and we then took it to the bank and have increased that to $10,000. Maybe that'll be a deterrent. Maybe it won't, but certainly 10,000 will catch the eyes more than 2,500.
Well, it certainly should. And I think the message is, hey, the Court of Appeals checks every cite. Don't think you can just cite something and make it up.
Right.
You guys go deep into the briefs and check and make sure everything's accurate, which I think is very important to know.
Right. Absolutely.
One thing I've wondered about, and I want to know your opinion, is your oral arguments in the Court of Appeals are 15 minutes, which goes by like the blink of an eye, in my opinion. And I've had a conversation with one of your colleagues, Judge Steve Dillard, about this, and I thought he would take the suggestion and run with it. He hasn't yet, but I've suggested your arguments should be at least 20 minutes. And then he said, "Oh, but I always grant people extra time."
I was just about to say that. Dillard always gives people more time.
He does. What are your thoughts? Do you get enough out of the 15 minutes? To me, when I argue in the Court of Appeals, it's just I barely get 2 sentences out and the time's over.
Yeah. Well, I would say in some cases 15 minutes is too long, but in most cases it's probably about right. It's certainly, I have granted additional time in cases that have been assigned to me when asked for, when it's appropriate. I would say, though, and I doubt that you do this and Lester does this, but don't regurgitate your brief. Don't tell us what the case is about. We already know. I mean, yeah. I'm not going to throw them under the bus, but I've talked to judges that served long ago, and they used to like the record being. Of course, there were a lot more oral arguments back then, and they might not have been able to have the time to get ready like we do, because we only grant them about a third of the time. But back then, I remember as a young lawyer, I would stand up and say, the facts of the case are so-and-so. And here, I would talk about things that you don't need to waste your time doing. So what I would do is just, suggest to those that are arguing to focus on the main points first. And then, we're kind of a hot bench. In other words, we ask a lot of questions and then respond to those questions. That's really the best part of oral argument for me, is the dialogue with the lawyer to talk about what the substance of the enumerations that are at issue that are going to be dispositive on the case. And so I try to focus on that. I will let people talk more. I don't try to interrupt too much. There's a court that sits above us, I think, that probably does a little more of that than we do. But choose your words wisely and talk about the things that are important with the case.
So, talking about, speaking of dialogue, we've had several Court of Appeals judges on. I know we had Dillard, and Ann Barnes was on. And I've asked every Court of Appeals judge that we've had on this question. So I can't break my string here, and I'm going to ask you. In South Carolina, where I went to law school, I'm not a member of the bar over there, but in working over there when I was in law school, and one of my good friends from law school was on the South Carolina Court of Appeals. But they have when they have an oral argument, and like they may have 3 cases or 4 cases or whatever, they hear the argument and then they leave and they go into one of the little conference rooms and they sort of talk about it for about 10, 15 minutes and take a sort of preliminary vote that nobody is bound by. But they actually get together and discuss the case. And my understanding, and you can correct me if I'm wrong, but that in the Georgia Court of Appeals, while, the only time, even in a case with oral argument, that all the judges may be together actually in the same room about that case is when you have the oral argument.
There are 15 different judges, and so they do it 15 different ways, or there are 5 panels, so I guess they do it 5 different ways. I will tell you that almost always, unless it's pretty clear cut, when we walk back into the robing room and we're all there together because we have to take off our robe to put it back in the cabinet that they stay in, I ask the other judges what they think. So I will always engage in the dialogue with them, particularly if it's my case. I want to know how they feel about it. The only times that it hasn't happened is if the judge has a scheduling conflict and has to need to leave, but I'll still follow up with them later. So I always do it, similar to what you described about South Carolina, because I think it's important to know. But we do have dialogue about cases. We may not do it formally. I'll go literally walk into a judge's office and sit down and ask them what they think, or I'll send them. We do a lot of memos back and forth just because sometimes it's hard to find them at the time. And I don't want to interrupt them. If Judge Dillard is upstairs working on one of his opinions right now, I don't want to walk in his office and interrupt him. So I'll send him a memo saying, this is my question about this. What do you think? And so we interact differently, but we're not siloed off and not talking at all.
You mentioned en banc, which is where all of the judges of the Court of Appeals get together on one case. Have you had an en banc since you've been on the bench?
Oh, sure. We have, several of them every year. Not many, but and understand it's all done via writing. We never have an oral en banc. We don't have the physical capability to do that here in this building. I guess we all stand up on the bench.
15 of you up there,
right? I can't imagine 15 questioners, but I guess we could do it by Zoom too. The cases go en banc if we have a system by which, if we're overruling prior precedent or there's conflicting cases and there's a reason to go en banc, we will sometimes it's polls to determine, do we think we want to do it or not? Is it necessary? And then there's some that it goes mandatory. But then when it either is granted or goes full court, it's just voted one down the line with the opinions circulating. And sometimes we've had some close ones. We've had some that are, about half and half, obviously one more than half going the other way. Yeah. And, but I think that's healthy. I think that's good. And then, they can apply for cert and take it up. And it's something that divisive will probably get a cert grant.
So on the other end of the, those are complicated ones where you're overruling prior precedent or whatever. I recently had a case that got affirmed, a verdict, a case that I'd tried, and it got a Rule 36, I think it is, where it's just, affirmed, which the trial judge was our friend, Judge Scott Smith. And I thought, this is going to give him the big head, because it basically says, you didn't even come close to making an error, in this trial. We don't even need to point anything out. I thought it was kind of a ringing endorsement, of him. What kinds of, how does that come about? It's I know sort of the flip side of an en banc, but how does it come about that that some cases get decided that way?
It's a matter of volume. We have such high volume. We continue to be one of the busiest appellate courts in the country. There was, I think, in 2019, they deemed us the busiest. And of course, it went down during COVID, but the numbers currently are equal to or greater than what they were in 2019. So it's just a fact of volume. What people wouldn't know, though, that don't ask, and since you asked, I'll tell you, is that almost the same amount of work, and I say almost, I mean, pretty close to the same amount of work goes into it. We still write internal memos that are almost to the level of an opinion, that never get put out there, so you don't see the work involved. But, if a trial judge writes a very good order that explains everything, there's really no need for us to publish an opinion that says the same thing. Interestingly, about 5 years ago, shortly after I was on the bench, I've been on the bench about 7.5 years, so it may have even been 6 years ago. I hadn't been on there long. I went to a council of state court judges, and I was on a panel with Brian Rickman and someone else and me, and they brought up that they didn't like Rule 36s because they wanted us to brag about them and say it publicly. But I think the Rule 36 says that. I think the Rule 36 says you got it right. We don't need to say anymore. But some trial judges don't like Rule 36s, and I've run into some litigants that don't like it because they think that we're just giving it short shrift. But the truth is, it's not. It's given the same attention as any other case. We just don't spend the extra time polishing up an opinion that is put out. But
it's nice when it affirms your side. I'll say that.
Well, no, we don't ever publish a rule. I guess, it's only for affirmance. That's the only time we do with 36.
You wouldn't, and the one that I got, I'm assuming it's a form order, but the one that I got, I mean, it would apply to any case. There wasn't anything in it that you would even know what the facts were, that it would have any precedential value,
Correct.
Yeah. Judge Hodges, let's talk a little bit about your judicial philosophy. It seems like we have a lot of appellate judges now who want to focus on textualism, they say, where it's, let's just look at the text of the statute. Some who call themselves strict constructionists, strictly construe every word. Where do you see yourself in the judicial philosophy spectrum?
Well, those labels, I think, certainly more aptly apply to a constitutional court, as in a Supreme Court that deals with those kinds of issues. We don't deal with constitutional issues. We don't deal with interpretation. We have to apply the law that the legislature has promulgated, whether we agree with it or not. And my judicial philosophy, as you say, is to apply the law as fairly and correctly as possible. And there have been times that I didn't agree with it, but I had to do what I had to do. So I really do, as the Beal versus Latham case sets out, give deference to the legislature. I mean, that they're the ones that write the laws. We're not there. We're not here to write them. We're not here to make law. It's our job to follow the rule of law. And again, I take that seriously, and that's what we do here on the Court of Appeals. And you can argue that above, at the Supreme Court level, they could do more of the, interpretation, the originalism, the strict construction, the other terms that are used for judicial philosophy. But my philosophy is to treat everybody fairly and try to do it right.
Do you recall ever writing a dissent in any opinion where you didn't like the outcome based on the law? Like, I know that's the law and that's the way it has to be, but I don't like that.
Oh, yeah. And I've actually written majority opinions that I didn't like. And I'll give you the example. I don't remember the name of the case, but it was a young girl in Rome, Georgia, who was had a medical malpractice claim against the hospital, and the issue was whether or not the statute of repose precluded her bringing the action. It started out in federal court, and the federal judge kept it longer than past the statute before he dismissed it, which was the reason that it happened, that they couldn't bring it sooner in state court. And then they brought it, and they used the argument that COVID told, the emergency orders told the statute of repose. Well, the problem was the emergency order didn't list statutes of repose as something that could be told. And every single Supreme Court decision said statutes of repose cannot be told. And so I hated that. So I ruled that the case could not be brought. It was by one of our friends that argued it below and then on appeal. And I literally ran into him somewhere and said, please take that case up and please reverse me. I was the one that had to write the opinion, and I hated it. And he was actually on a date with somebody, and his date was sitting there saying, is he just messing with you? Which I wasn't messing with him. I wanted him to take it up on cert and reverse me, and he did. And I was the first one to call him and congratulate him and said, thank you. But as wrong as I think they might be upstairs, I cannot reverse one of their cases. Doesn't matter. I have to follow what they say is the law. And so that's what I did in this case. And of course, when they heard it, they said, well, that's not what we said. Well, it's exactly what they said. They just they wanted the outcome that I wanted. I couldn't give them the outcome that I wanted to, but they can do the outcome that they want to.
Yeah. Especially during COVID, when that was just such a rough time, when everything was in doubt.
Right.
We have talked a little bit on our podcast about the rule of law and what our guests, how our guests see the state of the rule of law right now. You and I have talked about so many threats on judges, and Justice Ben Land, who used to be on the Court of Appeals, now on the Supreme Court of Justice, gave a speech to the Georgia trial lawyers about the threats on the judiciary. I'd kind of like to know what your thoughts are on where are we with the rule of law? Is it threatened right now? Is it strong? Is it weak? What are your thoughts?
Well, I think Georgia does it better than a lot of other places. I think the politics, by and large, are out of the judiciary in Georgia. Certainly, we're nonpartisan now, as we should be. But that doesn't mean that when there aren't highly political cases that get decided up here, people don't attribute political motivations and don't say things. And there are judges here that have been threatened. There are judges here that have had opposition mounted against them because of decisions that they've made, political opposition. And, while I believe in the right for people to run, I think when you've got judges that are doing their job, that because they disassociate politics from it, I don't think that should make them vulnerable to political retribution. But that happens. But I think here less in Georgia than most places. I do think the rule of law is followed here. But I am worried about judicial security. Thankfully, we've got fantastic security here at the courthouse, and I've never felt like I'm not safe in my job. But once you get out into the world, I mean, if somebody really wanted to do harm to you or your family, they could, and that's scary. But I think we all need to be cognizant of that, and we need to make sure that we do everything that we can to protect the integrity of the judicial system.
Totally agree. And I've had a similar conversation with the Chief Justice about this, and he agreed with you. He said he sees a lot of partisan politics in appellate courts in other states, but that Georgia seems to be getting it right. and that we're doing a much better job of keeping politics out of it. I hate it when somebody talks about a judge and they say who appointed the judge, as if that's going to matter. In my opinion, that shouldn't matter. Now, with you ran. You were like Ellington. Judge Ellington. You ran for office, which is rare.
That might get you held in contempt. You're like Ellington.
I was appointed by the people.
Exactly. That's about as good as it gets. So no one can attach any kind of partisan stuff to you. But the Chief Justice agreed that he thought Georgia does a better job than most states. I was worried about what you think about security. I agree with you. We have a state-of-the-art judicial center where your court is, and that might, when I'm in that judicial center, that might be the safest I ever feel in my life, because I know nothing's going to happen in here. And I'm not, I'm just a citizen. I'm not a judge, but I can imagine what it must be like when you're out and, people know you're an appellate court judge making pretty big decisions that affect people's lives. Let's talk a little bit, just briefly. I wanted to ask just a couple of personal questions if you feel like responding. One thing I'd like to ask is, what do you think is the hardest part of your job?
Well, dealing with the volume there, we have what's called a 2-term rule in Georgia, as you're both well aware, which most states don't have, which I think is a wonderful thing, because it means that within 8 months of your case getting docketed, you will get a decision whether you like it or not. So we move the cases, they don't linger here, and that's good. And keeping up with that can be tough. But as we've also pointed out on the podcast, I've got to deal with at least 2 others and sometimes 12 other judges and getting cases out. And not everyone likes to move on my timetable. I have brought up that I wish, and we have an aspirational goal of being done 30 days before distress. But there are some that they're going to wait till the last day to get it done, which can be problematic, because then it comes to me and I've got to make decisions a lot more quickly than I should. Yeah. I think decisions are always better made when you've got enough time to reflect on it. So, that's probably the biggest problem, is the volume. And, to that end, I'll give you a news flash. And it's not that much of a news flash, because they came out last year and said it in their opinion. The Supreme Court, I think, is about to transfer murder jurisdiction down to our court, which is going to give us a large percentage of their caseload with no additional resources for us to handle it. What is that going to mean? I think it's going to mean that fewer oral arguments are going to get granted, fewer interlocutory discretionary applications are going to get granted.
Especially in civil cases?
Well, yeah, right. And then less time is going to be spent on the important issues of any case before us if we've got a higher volume with no more resources to handle it. Unfortunately, we're not able to pay our staff attorneys, I think, a competitive rate. And we've been seeing lately a lot of our staff attorneys leave to go into the private sector, where they can double, triple, and quadruple their salaries, which I have seen recently. And, the work we do here is very important. And thankfully, we've got people that want to do it. And frankly, the job of staff attorney is nothing that I know Lester Tate or Ken Hodges would want to do. Robin Clark, maybe. I know her daughter's an excellent staff attorney, but research and writing is not what I love. I love the other aspects of the job. And so when we find good people like that, we've got to be able to recruit and retain them and keep them and pay them. And right now, we're not able to do that. So that's another tough part of the job, is maintaining a professional staff that's supportive of us being able to accomplish our very, very daunting task of processing all the cases we have.
When you're talking about the change in jurisdiction, I never figured out whose bright idea this was, but for many, many years, any divorce or domestic relations litigation went straight to the Georgia Supreme Court, and I mean, I guess for our listeners, maybe I hope we have some listeners that are domestic relations practitioners. I am proud to say that I got out of the divorce business about 25 years ago. Although I did try, I think I jury tried 2 or 3, divorces back in the day. But it's difficult and it's hard work, and the cases are sometimes quite messy and quite lengthy. How much, when you all got the divorce jurisdiction, because I got to argue, I think the very first day y'all were in the new building down there, and the case in front of me, which Bill Custer was on, by the way, our friend, was actually a divorce case. It had to do with a arbitration agreement and other stuff, so it wasn't technically that. But how much has that added to your caseload already?
Well, it obviously has, and the only way that the divorce cases come to us is by application, and so and we have to, in the application, see whether it has the possible merit to it before we'll grant it. But yeah, we've got some. I mean, and so it does increase the workload, which is interesting as to why we now see them wanting to jettison more jurisdiction down our way.
Oh, that's funny. Well, that'll be interesting to watch when that happens. And I foresee the presiding justice or the chief judge going to the legislature and asking for some more seats on the Court of Appeals if that happens. I don't see how your court can handle another whole jurisdiction like that. But that's
and it's
me.
a significant percentage of what they do.
Correct.
So I don't know what they want to do to fill their time with. But we would either need another panel or another staff attorney per judge, and either one is going to cost millions, 3 to 5 ish. And the legislature, God bless them, and they've been good to us lately, but there have been long periods of time where we haven't had the resources we need. We don't have all we need yet for the staff attorneys, as I just mentioned. And if we go to them and asking for $5 million on an ongoing basis to handle murder, when murder's already been handled upstairs, I don't know what they're going to say.
Be interesting conversation.
Yeah.
What would you want the average layperson to know about the Georgia appellate courts, the Georgia Court of Appeals?
Well, I think that, as I've already said, that I think we do it in Georgia better than most other places. Places like North Carolina, where it's partisan, Wisconsin, and other places where it's sometimes even Alabama, I think, is partisan. It's almost dysfunctional in some of these places.
Right.
I really do think that the judges here are collegial, and they try to work together and find the right answer, even though our backgrounds may be different. I think that you really do get a fair shake here. I don't think there's an agenda by anyone here, even those that are on the spectrum very different than me. We tend to see things, we try to play it down the middle, and everyone tries to be fair about it. It's a hardworking court, and I think that people are getting their money's worth for sure. Texas, for example, I think has maybe twice the population, but 4 times the amount of judges. I forget the number, but they got way more appellate judges than we do. Florida does it in a district setting where you've got districts that hold legal principles one way and other districts another way. So the law is different depending on whether you live in South Florida or North Florida. And here in Georgia, because we've got one central appellate court, which is, by the way, very geographically diverse from the members, doesn't have districts, which cause competing opinions and precedent against each other, which is good. So, I think we've got a great system here, especially with the Supreme Court keeping murder, but, they might not do that.
Put another word in for that.
New meaning to the term "you've been murdered," right?
You Judge Hodges, your faith, does it play a role in your job? Does it direct your decisions or play any role in how you look at a case, how you decide a case?
I strongly believe in separation of church and state. And so the short answer is no, but because of my beliefs of morality and ethics and treating people fairly and respectfully, I mean, I certainly carry that over into my work. So that's a guiding principle. But no, I don't let any religious philosophy that guide what I do. I can't. I don't think I'm allowed to.
Do you have a favorite philosopher?
I've always been partial to Thomas Carlyle. I think you've got his book right over your shoulder.
I think I do. That's correct. Yep.
That's neat. Okay. Well, we have been going for a little bit over an hour, and we don't want to take too much more of your time, Judge Hodges. We need you to get back to work for the taxpayers of Georgia. But we always ask our guests, our last question, we ask the same question of every guest, and that is, what is your definition of justice?
The problem is, I think it's different in every single case, and I think every single case should be treated differently. I don't think there's cookie cutter justice. I don't think there's one answer that we can apply to that question. And usually half the time the decision's made, half the people are going to be upset about it. I have had lawyers come up to me, one lawyer in particular, I won't name him, but he came up to me and I'd ruled against him. He goes, I read your opinion. And I went, okay. He said, made me mad. Okay. So read it again. Okay. I think you're right.
Okay.
Okay.
He conceded.
And that was nice. And just like when I write opinions that I don't agree with, but I feel like I have to do it, I feel like I do it because it's the right thing to do. I still remember early in my career on the bench, I have staff meetings usually every Tuesday, but today I actually had them today, earlier this morning, and I bring all my staff attorneys in and we talk about the cases and what's going on. And I brought up a case and I said, tell me how I can write the opinion that says blah. And they said, well, you'd have to ignore all law and precedent to do that. I said, well, I guess we're not going to write that opinion then.
That's a problem.
Right. So I think justice is you get honest, fair-minded judges and folks trying to get it right. And we try to get it right.
Well, I think that's a great aspiration, and I know you sincerely work at that every single day, and we appreciate you, Judge Hodges. We appreciate you.
Very much so.
Yeah. Again, we've been talking with the Honorable Kenneth Hodges, Judge of the Georgia Court of Appeals. You may learn more about the court and watch oral arguments, as he mentioned, at gaappeals.gov. So check out those oral arguments there. Thank you, Judge Hodges.
Thank y'all for having me. Y'all have a great day.
Thank you.
Well, listeners, that was a great conversation we had with Judge Ken Hodges. I really appreciate his time and respect him so much. Now is the time in our program where Lester and I like to talk about one item in the news related to the law that we found particularly interesting and newsworthy for our listeners. And Lester, I'm tossing it to you.
Yeah, the one I want to talk about it's on ABC News, was first put out July the 17th and then updated July the 20th. And the headline reads, Family says Chat GPT led Alabama woman to her death in new lawsuit. And it talks about a 29-year-old woman from Alabama who stepped into traffic on the interstate, killing herself. And her family has filed what this article terms a sweeping wrongful death lawsuit against OpenAI, alleging that ChatGPT manipulated her through months of increasingly disturbing conversations that culminated in her death. It was filed in the San Francisco Superior Court, and it actually has excerpts in this piece about what was said back and forth between the woman who had been psychiatrically hospitalized at one point, But, at one point, attorneys claimed ChatGPT repeatedly told Madison that she would need to die before becoming who she was meant to be. Among the quoted exchanges included in the lawsuit are, quote, "You are not done, but you must die first."
Oh my
Another
God.
allegedly said, "You must let this version of yourself die with dignity." And then in one of her last exchanges, she says, "I am ready." And the ChatGPT replies, "Yes, you are ready." And the thing that's interesting to me, and by the way, too, does not have a copy of the complaint. I tried to look back to see, but it says the complaint alleges 7 causes of action in this article: strict product liability, failure to warn, negligent design, negligent failure to warn, negligence per se, wrongful death, and a survival action, which is basically what you would see in a products liability, type case. You may have heard that in Los Angeles there was a verdict in an addiction over some of the social media. This is a lot more, of course, interactive, but it's interesting to me that this new technology is evolving. We again have the judicial system that's going to take a look and see, is it wrongfully affecting and interfering, in people's lives? And I think you will see much more of this type of litigation. I also would expect that in the discovery phase of this, you'll probably learn that a lot of the AI folks know what the dangers are, know what the risks are, and we repeatedly see that in products liability. And of course, there's going to be some risk to every product, but then comes the question, is that an unreasonable risk or one that could have been worked out? But that's my pitch for today, my piece for today, I should say.
That's just sounds so tragic. And like you said, if it's a products liability scheme, it's going to be a risk utility analysis. But that is awful. When I heard you telling the facts of that just strikes me as horrific, and that should not happen.
Yeah.
Period.
Yeah.
So that's very upsetting. My little piece is not as upsetting. I went for more humor.
Well, good. We can end on a high note.
We can end on a funny note. To me, it's funny, but it's going up to the United States Supreme Court. And the headline is, the Supreme Court, United States Supreme Court, is to decide if a man will lose his plane over an illicit 6-pack of Budweiser. And this story is about pilot Ken Hodges. I don't know if I'm pronouncing his name correctly. Who was about to take off in his 1969 Cessna airplane to shuttle a passenger to a remote village in Alaska when state troopers stopped the plane and searched it and found a 6-pack of Budweiser. And the problem was he was taking his passenger for a town called Beaver, Alaska, which is a dry village that bans alcohol. And it bans even bringing a 6-pack on your plane to bring it into Beaver. And the authorities in Alaska, and this happened back in 2012, so 14 years ago,
Wow.
They confiscated his plane and have had it since 2012. And he's fought it all the way to the United States Supreme Court. The Alaska Supreme Court said they thought it was proper to, he was charged with violation of law and sentenced to 3 days in jail and fined $1,500. He served his time, but he can't get his plane back. And it sits on a tarmac in Alaska right now, and he's trying to get his Cessna back. And he says, I'm in my 80s now, and I've been fighting this for over a decade because I see it as my duty to ensure that the Bill of Rights actually means something in protecting against government overreach. Well said. Well said.
Yeah, that's fascinating. Fascinating. And my country lawyer spidey senses are just tingling here that there is more to this case than will appear in the record that goes to the Supreme Court. Somebody didn't like this guy, or there was something else that went on that the authorities were not fond of, is sort of my gut impression about it.
Well, I think this is going to be heard on Monday in the United States Supreme Court. And also, as Judge Hodges said, you can listen to the United States Supreme Court online as well.
I thought they had adjourned for the year.
Oh, have they? Well, this says they just agreed to hear it. They granted cert. Yeah.
Okay. Yeah.
But the issue will be
in October. Yeah.
You're right. The issue will be whether the taking of his plane amounts to a violation of the Constitution's guarantee to be free of excessive fines. And he says a $95,000 Cessna plane is too much for a six-pack of Bud.
And, the Supreme Court has, you'll remember there was the case that was out of Alabama where the guy got a large verdict because I think they'd put, there was the doctor that they had put used parts on his car or something like that. I can't remember what it was, but that's the case that has to do with punitive damages, where
that was a BMW. Yeah.
The U.S. Supreme Court, they sort of engaged in what I would call Goldilocks-ing. This porridge is too hot, this porridge is too cold. No, this is just right. So that sounds like some pretty hot porridge to take your $95,000 plane.
It seems a little much. I hope he gets his plane back, but we'll see in October, I guess.
Yeah. And what kind of beer did he have? That's what
it says it was Budweiser, a six-pack. Right. But my guess is
Bush should join him amicus curiae.
They should. You're right. I'm thinking that the town of Beaver, Alaska, might need a six-pack of Budweiser.
Yep. I think you're right.
All right, Lester.
All right.
Enjoyed it.
I did too. Good guest. Good. Always good fellowship here. So
yeah, we want to thank our sponsor, the Georgia Civil Justice System, and you may learn more about that foundation. It's the Georgia Civil Foundation at fairplay.org. We thank our producer, Philip Hoover, and we thank our listeners. You can learn more about Lester at aikentate.com and more about me, Robin Frazer Clark, at gatriallawyers.net. And you may listen to our episodes of the podcast at seeyouincourtpodcast.org or anywhere you get your podcast. And you can find us on youtube.com, where now we have over 214,455 views. How about that? That's pretty cool.
I like it. I like it.
All right, my friend. Until next time,
I'll see you in court.
You've been listening to the See You in Court podcast, brought to you by the Georgia Civil Justice Foundation. Remember, justice is a shared journey, and your engagement makes all the difference. For further insight and resources, visit our website at www.seeyouincourtpodcast.org. Subscribe to our YouTube channel at See You in Court Podcast for additional content. And don't forget to engage with our community on facebook.com/seeyouincourtpodcast. Special thanks to our producer, Philip Hoover. I'm Fred Smith, Executive Director of the Georgia Civil Justice Foundation. You may learn more about the foundation at www.fairplay.org. Until next time, we'll see you in court.